Now, before we get into the modern legal framework of POWs, it's important to understand the historical context or the historical foundation that this legal status is built on, and understand that POWs, obviously they're people, but that is a legal status, a tag that is applied to someone that offers a certain set of legal protections. In the world of IHL and the world of the legal protections that IHL offers during armed conflicts, there's perhaps no provision that's more commonly maybe understood or just sort of publicly aware about than POWs. It's a term that gets thrown around in pop culture all the time. It's a term that we see on POW MIA flags if you're driving around, maybe on government buildings, that sort of thing. It is not foreign to most folks. But what might be surprising, and what we'll dive into today, is the extent of the current protections under modern IHL that exist for prisoners of war and why those protections exist. But let's roll back the clock to a time before modern IHL existed, and look at where prisoners of war sort of stood in the grand scheme of things. And the answer is not great. If we go back to antiquity, probably one of the worst things that could happen to you would be to be captured on the battlefield. Any number of awful sort of situations awaited you if you were captured. Summary executions, being forced into slavery. Old Maximus gave us an example of that. Mutilation, rampant sexual abuse. There was an outright cruelty that was simply accepted for those who were captured, taken prisoner during conflict. There was not a regime of protection for these individuals. And that's because prisoners of war, that title really didn't exist at this point in history, but prisoners taken during wartime were considered property. You were chattel, to pull on the law school term for it. You were a thing, not a human being, and you were treated as such. You were either discarded, your life was discarded, or you were abused in such a way that a piece of property might be. Things didn't get a whole lot better as you move forward into the Middle Ages. Think of a glacier advancing on the land. That was the pace of progress and change for prisoners of war. You did see during the time of knights a form of or an arm of chivalry, this idea of sort of professional, gentlemanly conduct emerge amongst combatants, in particular knights. And this system of ransoms came about, one in which, especially for higher value prisoners, things like knights, there would be things exchanged in order to secure a prisoner's freedom. That might be money. It could be political concessions. It could be military concessions. Hey, we'll remove our forces from this area, or we'll let you have this particular spot of land if you'll exchange these prisoners for us. But also overlaid during this Middle Age process was a religious influence. The idea that if you were in a religious-based war against a foe that was a different religion than yours, that they were somehow subhuman, that your prescribed faith called upon you to kill those folks. They were seen as less than or an enemy of sorts. And so you saw this religious influence really drive some of the cruelty that continued to perpetuate itself throughout the Middle Ages. We move forward into the 18th and 19th centuries. We'll come across the shores, the Atlantic Ocean to the shores of the U.S. And that glacial progress really seemed to continue. There weren't massive leaps. And in fact, during the American Revolution, you saw some really awful treatment of prisoners, in particular colonial prisoners, American prisoners, at the hands of the British. You have an image there, held afloat, these prison ships that the British employed to house captured Americans, captured colonials, captured patriots, whatever term you want to pull to describe those individuals. They were used in rampant fashion. So these were vessels, Royal Navy vessels that were anchored. One of the most notorious of those was the HMS Jersey, also nicknamed Hell Afloat. That's the image there, anchored in Wallabout Bay in New York. And the conditions were awful here. Starvation was common. Death was almost a relief for prisoners who were kept in circumstances like these. They were crowded. There was no medical care. Disease ran rampant. Abuse ran rampant. There was very little regard to the individuals who were captured and held aboard vessels like this. You move forward into the American Civil War, and you have an evolution of that sort of ransom system that I described from the Middle Ages. You had something called the Dix Hill Cartel. Now, this sounds like maybe a drug smuggling ring. It's not. This was an agreement, an unofficial agreement. So, meaning this wasn't the product of legislative action between the Union and the Confederacy, but this was an agreement between a Union and a Confederate general to establish a system of prisoner exchanges. So this was relatively unique for the time, given the scale of this prisoner exchange, but this set forth a set of conditions in which the Confederacy and the Union could exchange prisoners, often in large numbers. And it really led to a system where those prisoners could look forward to the possibility of release as opposed to being kept in those awful conditions that they sometimes faced. Now, also within the Civil War, in 1863, you had sort of a revolutionary change happen at the hands of President Lincoln. That was known as General Order 100, better known as the Lieber Code. This is a set of rules laid down for Union forces, Union armed forces, prescribing their conduct within the armed conflict. There wasn't an analogous document or an analogous order for the Confederate Army, but Lincoln looked at the conduct of the war, some of the gaps in protection that were happening, both to individuals fighting and to the property that was being destroyed in the war, tapped Joseph Lieber to craft a set of rules that would guide Union forces in their conduct. When it comes to prisoners, it laid down a really, I would say, revolutionary set of protections. It guaranteed humane treatment for those captured. It set aside or ignored racial distinctions for captives in terms of how they would be treated, racial distinctions that absolutely existed and persisted for those captured by the Confederates. It set down a fairly robust, at least in comparison to what came before it, set of protections or assurances for those captured. The idea here was that those who were captured were uniquely vulnerable, in a uniquely vulnerable state. And so, at least from the Union's perspective, there was an obligation owed, a certain level of professionalism, chivalry, if you like, to those prisoners to look after their well-being, to ensure that they were cared for, that they were spared from physical violence, from things like torture, etc. This was really revolutionary. Think about 1863, the time where this came into being. These protections were put into place at a time where the outcome of that war was not certain. It wasn't absolutely certain that the Union was going to win, that the United States would reunite, and that the Union would prevail. And so to establish a set of protections like this, especially considering in the realm of prisoners, some of the rampant abuses that were happening on the Confederate side, this was really revolutionary. This was, I'd like to think, a statement of IHL as a whole, that you had a side that was concerned with humanity itself, that was concerned with those protections. It didn't matter what the opponent was doing. It didn't matter what violations were happening by the enemy, in this case, the Confederate States. What mattered were those principles of humanity. And so President Lincoln committed to those with regard to prisoners and more with General Order 100. And it really set the stage for what we know as modern IHL. As the 19th century turned to the 20th, you had a revolutionary set of treaties known as the Hague Regulations. I say revolutionary because before that, really the only international treaty that existed, so understand the Lieber Code was limited to applying to U.S. forces, the U.S. military. You had the first Geneva Convention come along in the mid 19th century. That was really limited to wounded on the battlefield, those who got wounded, those who were trying to provide medical care for the wounded. That was really the genesis of this international treaty system that we see form the backbone of IHL today. But that was it until 1899 and 1907, when you had the Hague Conventions give birth to the Hague Regulations. If you go back and look at the text of these documents, still good law, but they're really forward thinking when you imagine yourself in the shoes of those drafters at that time. They looked at a lot of really advanced concepts in armed conflict. They didn't shy away from things that were cutting edge, things like poisonous gases, balloon warfare, and the like. And prisoners of war, or the fate of those detained in armed conflict, were also included. And so within Hague, you saw an enshrinement of things like humane care, protection from violence, so echoes of what the Lieber Code provided for U.S. forces. It also provided certain additional protections, things like prescribing what labor prisoners of war could be made to do, attending to their basic needs, something as simple as enshrining the ability or the right for a prisoner of war to send and receive mail while they were captured. These basic elements of humanity that went beyond just protecting them from basic abuses to ensuring that they were able to retain some semblance of their humanity while they were captive. The Great War, World War One, breaks out in the early 1910s, and you see prisoners taken on a scale that was unheard of. I mean, the war itself, World War One, was on a scale that was unheard of for armed conflict across the world. And through the course of the war, some 7 to 9 million soldiers were taken prisoner during that conflict on both sides. That number is roughly equivalent to the entire population of New York City, modern day. So think about the entire population of New York being captive at one point or another during the war. That's a staggering number. Some 10% of those taken prisoner, that total population was died in captivity. So you're talking about somewhere in the order of 750,000 to more than 1 million individuals. It's a substantial number. And while conditions undoubtedly compared to maybe the Antiquities or the Civil War or the American Revolution, conditions had improved. The conditions in which soldiers lived, the conditions in which those prisoners were treated, some of the things that they had access to, there were still rampant abuses on both sides. There was not a uniformity in treatment that always exists in armed conflict. A prisoner in one theater or in one internment camp may see very different conditions from another. But there was an outcry, there was a recognition that it seemed as if all of these protections, all of these affirmations by countries, by both the Allies and the Central Powers, that they would adhere to Hague, really went out the window when the bullets started flying. And so you had a push post-World War One to address that. There wasn't the same comprehensive push to revamp IHL as there was after World War II, which we'll get to in a second. But you did have a new Geneva Convention, the 1929 Geneva Convention on the treatment of prisoners of war, that really aimed to address the gaps that the Hague Regulations had, that really aimed to address some of those atrocities that prisoners had faced during the Great War. Fast forward to World War II, and I would argue you saw a somewhat of a backslide in the treatment of prisoners of war, if that was possible. Again, a war on a massive scale, a global scale, and prisoners taken on a similarly massive scale across the war. And the atrocities that were faced by prisoners, particularly those in the Pacific Front, are well documented. In 1949, the world came together in the ashes of World War II, facing down the destructiveness of that war, and in particular, the atrocities faced by prisoners of war. And they crafted what we know today as the 4 Geneva Conventions of 1949. Of those, Geneva Convention 3 specifically dealt with prisoners of war. It replaced the 1929 POW Convention. It is universally accepted, as are the other three Geneva Conventions. So those four GCs are one of the only sets of international treaties that are universally accepted to this day. And GC3, as I'll refer to it to, requires countries to follow it in all circumstances, even if you're following it unilaterally. So another country, another party to an armed conflict, their breaking of or their violations of GC3 doesn't give you or doesn't give a nation a blank check to violate it or to set aside the protections in GC3. War evolved after World War II. You saw a move away from these international armed conflicts, as we'll touch on in a moment, countries fighting countries, and you had an advent of proxy wars, non-state groups, fueled, armed, trained by countries. And so you had countries sort of fighting each other through proxies in various areas of the world. You had a number of struggles against colonial or foreign influences throughout the world. And you had a rise in what up to that point hadn't been a major focus of IHL, but what became known as non-international armed conflicts. This became a real problem point for the international community looking at the protections that IHL was offering. Because as we'll see in a minute, the four Geneva Conventions, classic IHL as a whole, it really was built around the notion of countries fighting countries, those classic international armed conflicts. IHL wasn't built, the bulk of it wasn't devised to apply to these non-international armed conflicts. And so you had a gap in protections that had a trickle-down effect and a direct impact on those detained by potentially putting them at a higher degree of risk. If those protections for international armed conflicts don't exist in non-international armed conflicts, what does that mean for the average prisoner in those conflicts? That gave birth to the additional protocols of 1977. So these are additional protocols to the Geneva Conventions, and specifically the second additional protocol dealt with non-international armed conflicts. So with that history in mind, let's look at the legal framework under GC3 in modern IHL. And it's appropriate to ask at the start, what is a prisoner of war? Who is a prisoner of war? Well, this is a combatant. That's a key term we'll unpack in a moment, who falls into the hands of an adverse party to a conflict in the course of an international armed conflict. So it has to be a combatant. Only combatants can qualify for POW status, and they have to be taken prisoner during an international armed conflict. Now, understandably, you can fall into the hands of an adversary in a number of ways. You could surrender, you could be captured as a result of a lost battle, etc. The phraseology there is important because it expands the definition there beyond just those who surrender. So that's key. Think about a battle in which the enemy doesn't surrender. They're just captured. If this language wasn't broad like this, you could easily have a situation in which those people were able to be killed, executed, instead of being considered prisoners of war. So it's important that it had that broad scope. Now, I mentioned international and non-international armed conflicts. There's a difference between the two that we've already unpacked, but let's see exactly where that lies. So for international armed conflicts, a different set of IHL applies compared to non-international armed conflicts. As I said, IACs, as they're called, are countries versus countries. So a state versus a state, and they use armed force against each other. The full body of IHL applies. Common Article 2 to the Geneva Conventions, the full application of those four Geneva Conventions apply, and therefore POW status exists during an international armed conflict. Classic example of this that we'll touch on from time to time in this presentation is the current Ukraine conflict that broke out in its most recent iteration in 2002 with the Russian invasion of that country. That is a classical international armed conflict between Ukraine and Russia. Now, When we switch over to non-international armed conflicts, things like those proxy wars that dominated the 20th century, a much narrower scope of IHL applies. So Common Article 3 to the Geneva Conventions, which is much narrower in its breadth compared to Common Article 2. Additional Protocol 2, which specifically applies to non-international armed conflicts. Domestic laws apply where they exist and are applicable. There is no such thing as a prisoner of war status during non-international armed conflicts. That doesn't mean that there are no protections for those detained in a NIAC, but they don't have critically the benefit of GC3 in that full suite of protections that exist there. So you have to ask yourself what kind of conflict exists before you can declare an individual to be a POW or start thinking about the protections that they're owed. It matters once you get past, hey, this status exists, we're in an international armed conflict. It matters who the person is being taken captive or detained, right? I mentioned the definition of a POW extends to combatants, but really there are three basic categories of individuals who might be detained on a battlefield. Non-combatants, which we also refer to as retained persons. Combatants, that's your basic core category for POWs, and then civilians. Understand that a non-combatant, as we'll discuss momentarily here, a non-combatant may wear a military uniform. They may be a part of the military. They are sort of a subset, I would say. They aren't sort of classically considered a prisoner of war. That retained person is a specialized, I would say, off-branch status of prisoner of war, but they retain a specialized role. And civilians do not get that prisoner of war status in most cases. There are obvious or some exceptions to that. So let's look at GC3 Article 4. Who qualifies as a POW? Well, naturally, members of the armed forces qualify. The asterisk is there because you have to be abiding by IHL. So you have to fight by the rules in order to qualify as a POW. If you're out there committing IHL violations, you're not going to qualify as a POW. Certain partisans or organized resistance movements can qualify for POW status. Understand that within these groups, you could have individuals who might otherwise be considered a civilian in some aspects of their conduct. Those can qualify as POWs. Persons accompanying the armed forces. So I mentioned that caveat with that civilian category. Persons accompanying the armed forces frequently are civilians. Think about modern day armed conflict, places like Iraq, Afghanistan, where the U.S. has been involved for a long time. You think about the civilian contractors who are there, humanitarians who may be deployed, members of the Red Cross might be deployed, providing support to the armed forces. Those are still civilians, but if they're captured, they are considered persons accompanying the armed forces. They can or they are entitled to that POW status and those protections. And then levée en masse participants. A levée en masse is classically a civilian uprising in response to an invading force. Those are civilians by definition. These are people just taking up arms spontaneously to push back on an invading force. Even though they're civilians and ordinarily wouldn't qualify as POWs, their participation in a levée en masse qualifies them as POWs. Now, who can be denied POW status? Well, there's a few sort of malcontents, if you will. Mercenaries, so those fighting for a pay. I won't get into the sort of qualifiers. There's a six-part test under the additional protocols for who qualifies as a mercenary, but mercenaries don't qualify as POWs. They're treated as civilians. Spies don't qualify for POWs. Civilians who directly participate in hostilities. So if you're a civilian and you decide to take up arms, you're not a member of a partisan group, you're not a part of a levée en masse, you're just sort of taking part sporadically, perhaps in fighting, you're not going to be a POW. And then combatants who break the rules, in particular combatants who don't distinguish themselves by wearing a uniform, carrying their arms openly, etc. I want to come back to this business of non-combatants and their status as retained persons. So these are specialized prisoners. They are specialized members of the armed forces often. And classically, retained persons are your medical and religious personnel, your medics, your doctors, perhaps your dentist if they're captured, your chaplain personnel, etc. These individuals may visit with prisoners of war, so they are not themselves considered a prisoner of war. It's a sort of an offshot cousin category, if you will. They are retained persons, but they can offer their services to fellow prisoners of war. The idea here is that these individuals do not perform an offensive combat function on the battlefield. That's why they're considered non-combatants. And we want to, in the interest of humanity, in the interest of other prisoners, et cetera, we want these individuals, because of their specialized roles, to be able to continue providing those services, so they can continue offering those medical and religious services to other prisoners. They can't be forced to perform other work. So if other prisoners are being made to do cleanup work or other jobs around the camp, or outside the camp, they can't be made to do that work. They're limited to doing work aligned with their specialized non-combatant role. What happens if you don't know whether somebody should exist? I gave 3 categories there. Maybe you're confused. Maybe you're not sure whether a person is a POW. Maybe you're challenging someone's assertion that they're a POW. Hey, you're not entitled to these protections. You're not a prisoner of war. You're a civilian. You're not entitled to these all these protections. Well, when doubt exists, a few things come into play. Until you clear up that doubt, the default is to apply prisoner of war status and prisoners of war protections in the interim. And GC3 requires that a competent tribunal be held. Now, GC3 doesn't prescribe the exact procedures that are required, what constitutes a competent tribunal. The idea here is that we want some semblance of due process. We don't want a kangaroo determination of someone's POW status that really sets their interest aside and results in an inaccurate adjudication of their POW status. It also, on the opposite side of the spectrum, doesn't necessarily require a full-out criminal trial to ascertain beyond a reasonable doubt whether somebody is a POW. They leave it to the parties. And I'll use the United States as an example. Army Regulation 190-8 is the U.S. Army's manual regulation concerning those detained in conflict. And AR 190-8 sets forth a U.S. procedure for determining POW status. So this is unclassified. You can go Google this AR right now and see this all the instructions for one of these tribunals. It requires 3 members. It requires a recorder. That's just a phrase that refers to the person presenting the evidence on behalf of sort of the government or the military. There's no right to representation, so that POW is not entitled to an attorney, or that detainee is not entitled to an attorney. And the standard for proof here is a preponderance of the evidence. So is it more likely than not that this person is or is not entitled to POW status? So a relatively low bar, but like I said, this fits well within that competent tribunal framework that GC3 mandates. All right, get active in the chat here. What do we think? Captain John Miller, United States Army. He's a Ranger. This is World War II, 1944, and he's captured by German forces in that war. Is he a prisoner of war or not? What do we think? Classically, he is a prisoner of war. World War II, classic international armed conflict. He is clearly a combatant. He's a member of the United States Army, the United States Armed Forces. He would be a prisoner of war. Easy peasy. What about Commander James Bond? Did you know James Bond has a military rank? He is a commander. He's a part of British MI6. What about James Bond? Is he a prisoner of war? He's been captured at the hands of Le Chiffre, one of the best Bond villains in modern Bond history, Bond lore. Well, no. Classically, James Bond is a spy by definition. So any kind of military affiliation, military rank that he may have, he's on the battlefield, so to speak, as a spy, and he would not be entitled by rule to POW status. What do you think about Colonel Robert Gould Shaw, played by Matthew Broderick here in the fantastic movie Glory? So he's part of the U.S. Army. This is 1863, the Civil War. I got it. 1863 predates the Geneva Conventions. Let's pretend for a moment. What do we think? Oh no. If Colonel Shaw is captured in the context of the United States Civil War, this is classically a non-international armed conflict, and I'm making the assumption here that we are not treating the Confederate States as a sovereign nation. So, in the context of this, as a NIAC, Colonel Shaw would not be entitled to prisoner of war status. What about Chewbacca, part of the Rebel Alliance? I say that because I have to work Star Wars into everything. Well, it depends. Let's get nerdy for a second and roll up our nerd sleeves here, because in the original movies, A New Hope, Empire Strikes Back, Return of the Jedi, he's fighting in the Galactic Civil War. So the Star Wars version of the U.S. Civil War, I guess, if you will. He would not be entitled to POW status. There are other, because Chewbacca is a great veteran for the cause. There are other conflicts where maybe he would be entitled to POW status. I don't know, but classically, Rebels versus the Galactic Empire, not an international armed conflict. Sorry, Chewie, you're out of luck. Let's bring it modern day. What about Nicolas Maduro, the Venezuelan president? Very recently, he was captured by U.S. forces in a raid. And he, after being indicted and arraigned, or during his arraignment in pleading not guilty to his federal charges, declared that he is a prisoner of war during the hearing. I don't know the answer to this. I don't know whether 190-8 will be invoked to have some sort of competent tribunal. I don't know whether his counsel, his civilian defense counsel, will push for a POW determination, but this remains very relevant. This question of status remains very, very relevant even today. And this report was just from a week or two ago. So that status has real weight and effect. All right, so let's look at the protections for POWs under GC3, and they're quite extensive. So before we get into specifics, understand that it is the detaining power's responsibility for POW's treatment, regardless of anything. So no matter what an individual within, belonging to the detaining power has in terms of their responsibilities, the responsibility writ large rests on that detaining power to ensure that these protections are observed across the board for POWs. One of the most critical is that of evacuation. So POWs must be evacuated, and by that it means move far enough from combat to be out of danger. So the idea here is oftentimes prisoners are taken in the midst of combat operations, and that vulnerability is immediately triggered. If you were to keep them around the front line, if you were to do something like keep them around as shields or something like that, you can understand the danger that they would face without the ability to defend themselves. So GC3 prescribes that this has to happen as soon as possible. That doesn't require an immediacy that ignores the military circumstances, the necessity of what's happening on the ground. But what's important is that you can't unnecessarily expose the POWs to danger. So you couldn't put them, say, in a robo-taxi and send them along a route that's actively being shelled to try to evacuate them, right? You've got to take those precautions to protect them, but you get to balance that against the circumstances on the ground. So GC3 doesn't require that evacuation happen in a way that unnecessarily puts the detaining power or its forces at risk. They've got some judgment, some discretion in that realm. Combatant immunity is a critical concept. So combatant immunity is the idea that a combatant is asked to do many things that would otherwise be illegal under normal domestic law. I mean, at base, you're asked to kill the opposing force. Well, that's murder in normal domestic law. That's not the case. It's not that it's not considered a killing in warfare, but there's a recognition that combatants are asked to do those things. And when they're doing it lawfully, when they're doing it within the bounds of IHL, uh, you have to have some form of immunity. Otherwise, you're going to exit a war with an unending amount of criminal prosecutions for things that a soldier really, was forced to do in the context of their duty. So, combatant immunity as a concept is critical in armed conflict, and what it means is that you can't be prosecuted for lawful wartime acts. So, if you're in an armed conflict and you're obeying the rules, and you happen to do something that would otherwise be considered a crime under normal law, but is otherwise lawful under IHL, such as killing, then it is protected by combatant immunity. That protection, that combatant immunity, doesn't go away. So we'll touch on punishment for prisoners of war in just a bit, but understand that they don't lose combatant immunity. They can't be captured and then prosecuted for fighting against the detaining powers forces. They also can't be made to renounce their rights. They can't be made to say, well, if you want, I'll renounce my rights if you agree to treat my wounds that I suffered in battle. You can't leverage someone's protections, get them to give them up, coerce them to renounce their rights in exchange for something else. That's flat out not allowed. You also have to afford humane treatment to prisoners of war. That means protection against violence, protection against medical experiments, mutilation, intimidation, exposure to public curiosity. The public curiosity piece, as as history has evolved, as news media, as social media, this sort of connectedness that humanity has with one another has become increasingly important. We don't want POWs to be paraded around and made the subject or the object of public curiosity. Nowadays, it's very easy for that to come into question. So you take some prisoners in a battle and then march them down the street of a village that you've just liberated. Well, that's an easy image or video to spread around right now in the 21st century. Social media amplifies that ability and that sort of risk of degradation. And so it's equally as important now as it was when this was put into place in 1949. Importantly, they're able to access free medical care. You can't force them to pay or otherwise not qualify or be denied medical care for their wounds, to include wounds that were incurred on the battlefield, so before they were captured, and injuries or sicknesses, illnesses that they acquire in captivity. So there is an ongoing requirement to care medically for prisoners of war. You also have to have an equality of treatment and respect of honor of prisoners of war. This is especially important when it comes to prisoners of different genders, in some cases of different gender ideologies and whatnot. GC3 doesn't speak beyond the scope of genders and that sort of thing. But the idea here is we're talking about equality of treatment at a human level, right? You cannot distinguish or segregate, single out someone because of an aspect of their humanity for disparate treatment. No reprisals is key. A reprisal would be a punishment or some other sort of injury or insult that's inflicted on someone in retaliation for a perceived wrong that's done by that individual. So, for example, classic example, a hard-fought battle takes place in a village between two bitter enemies. One of those sides loses the battle, and a number of those individuals are captured. And the capturing force, the detaining power, is really angry. Those soldiers are really upset. They've lost friends. They're disgusted with the conduct of their enemy, and they're looking for revenge. Well, reprisals, taking that frustration or trying to punish those individuals simply by virtue of their status as a POW or a detained individual, are not allowed. Interrogation has some boundaries. So this isn't a hardline rule against questioning an individual, a prisoner of war. You can ask questions of a prisoner of war, but you can't cross the line into forcing them to divulge information, coercing them to divulge information with threats or actual physical violence, that sort of thing. Great example of this. Let's bring it back to Star Wars, right? The business of Princess Leia. She's captured at the very beginning of the movie by, ironically, her father. And they want to know where the hidden rebel base is. She's a great source of that information. She knows exactly where the hidden rebel base is. It's okay to ask her that. It's okay for her to be interrogated in the sense of being questioned even by somebody scary like Darth Vader. Where it crosses the line, and you see sort of both sides of this, is when you bring in a torture droid, that very scary little orb in the doorway in that bottom picture, and start to torture someone, torture a prisoner to get information out of. Let's not peel back the layers here. And like, hey, Thomas, you said that the Galactic Civil War doesn't have POWs. Let's set that aside. But this is a nice little juxtaposition of the interrogation rule. What about where you can house prisoners of war? What requirements are there for how you can intern them? Well, GC3 has a number of provisions regarding the kind of facilities that you must place POWs in. They have to be on land, so no more hella floats. You can't roll out HMS Jersey once again and put prisoners in prisoner ships. As armed conflict, theoretically expands into outer space, that'll be an interesting wrinkle to this. Do you have to bring prisoners taken in an outer space conflict back to a terrestrial facility? At least under GC3 right now, the answer is yes. You have to have conditions that are comparable to the detaining powers forces. So you can't have your troops housed in nice air-conditioned tents, and then you throw your POWs into hovels built out of Honey Nut Cheerio boxes. Doesn't have to be equal, right? You don't have to have the same exact set of facilities, but they can't be so disparate that a rational person would look and say, well, the detaining powers forces have just head and shoulders above in terms of quality of facilities. So there's got to be some comparability there. There's got to be sufficient billeting. So that's the housing, the roof over your head, food, water, clothing, and a canteen. Canteen is that little shop where you can theoretically buy items, use your POW bucks, which we'll get into momentarily. So it's not just that you need a roof over your head, but you've got to attend to the sustenance needs to include clothing for those prisoners of war. You have to provide adequate hygiene, infirmaries, so the places where you can go to get medical treatment and medical inspections. You can have retained personnel, so medics, doctors, etc., who are engaged in the provision of this kind of care. It is completely permissible for a detaining power to help provide this care through the business of retained persons. And this is really critical. You can imagine that, especially in a crowded POW facility, the business of hygiene, the business of disease outbreak or prevention, those become very real problems in and of themselves. You could have a healthy population of individuals that's captured, and they rapidly devolve into an unhealthy population if you're not attending to these basic things. You also have separate housing by gender. I mentioned that disparate treatment business. There's a recognition and sort of a concept that you saw before of honor that's built into across the Geneva Conventions, this idea that sort of an antiquated view of things, but a woman must retain her honor. The idea here is that you need to have these separate facilities to guard against violations of honor against female prisoners of war, but separate housing by gender. Let's talk POWs and work or their personal property. Now, I mentioned in history long ago, you had rampant slavery. It was very common for prisoners of war to be made slaves. Well, that has evolved mightily since then. You still can make prisoners of war work, but GC3 requires that it be assigned by rank. And there's a difference in the military between officers and enlisted or non-commissioned officers. There's a difference in the work that's prescribed. That's a sort of a rank structure difference that is expands into the roles that different types of soldiers play. Typically, your officers are in a senior supervisory or a commanding role, whereas non-commissioned officers are at a lower echelon of responsibility, supervisory responsibility, etc. The work that can be assigned by rank is reflected in those things. So the equally, if not more important, is the type of work that can be performed by a prisoner of war. Only certain types of work are allowed. They cannot be made to perform work that has a military character or purpose. You cannot put POWs to work furthering your war machine. So that would be something like taking POWs and putting them into an ammunition factory to make ammunition. This was a common feature in both World War II and World War I. In World War I, as the manpower for the Central Powers, Germany, etc., dwindled, they increasingly leaned on POWs to perform those war-type industry tasks. The scheme set forth by GC3 prohibits that. You can have them do other things, upkeep the POW facility, so do grounds work, etc. You can't have them do things that would further your war effort. And that includes fighting as well. You can't put a weapon in the hands of a POW and force them to fight on behalf of your side. Right now in Ukraine, Russian POWs across the 4 major POW camps that Ukraine has, they're doing things like locksmith work. It's voluntary. They're not forced to work, but they're doing these sort of basic tasks, basic jobs that might fit within their skill sets, or things that might expand their skill sets. They can't do any dangerous, unhealthy, or humiliating work. So you can't make them go do, hey, we have to attend to the hygiene, so we're going to make all of our POWs do the work of clearing out latrines and doing all sanitation work without protective gear. Can't do anything like that. So there is a boundary there to the type of work that they can do. Additionally, you can't make them work excessive hours. There's no grind culture for POWs. The GC3 doesn't prescribe like a 9-to-5 work schedule, but you can't grind POWs into dust, even if they're doing the type of work that's allowable otherwise. You also have to give them time off and rest. I don't think that was a concept when I had my first job at a grocery store. I don't think the grocery store I worked at recognized GC3 protections. I would have liked some time off perhaps, but you have to afford POWs regular time off and regular rest. Again, it's not like the US or European concept of like a 40-hour work week, but the idea here is that that's an important component of their humanity. I'm going to mail GC3 to my old grocery store that I worked at for my first job and say, hey, you guys should consider this. Now, interestingly, POWs can possess money and maintain money accounts. We're used to this sort of concept in the US in our civil prison system, where prisoners have a bank account of sorts that they can be sent money or earn money if they're doing work. Prisoner labor, they often use that money in the prison canteen. That sort of concept exists for POWs. They are allowed to do that sort of thing, to earn money, to keep money. POWs have to be paid according to their rank. That pay, there are other places in GC3 that just sort of leave the details up to the detaining power. This is not one of those areas. They prescribe the pay rate depending on your rank. The higher ranking folks earn more money, but it's set forth in CHF. So that's a Swiss franc. If you're unfamiliar with a Swiss franc, 8 Swiss francs these days in 2025 dollars, that's what is it? About just a few bucks for a couple of bucks per month, and 75 Swiss francs is not too much more than that. It's about $30 or $40 US. So they are earning money. You have to earn at least a quarter Swiss franc per day for each day of work. That's equivalent to about 39 cents US. So I did look to see if this was updated. Currently, there has been no update. Obviously, the GC3 has not been revised by the global community. But I looked at Ukraine. What practices is Ukraine as a detaining power? I couldn't find information on what Russia is doing with Ukrainian POWs, but Russian POWs are being paid, at least based on the public reporting that I saw, this 1/4 Swiss franc base pay rate for their work, and then that $8 to $75 Swiss franc rate for monthly for their work. So this is one of those vestiges. This didn't exactly scale with inflation, I don't think. I think it's interesting that the drafters thought to peg an exact dollar amount or an exact Swiss franc amount back in 1949, but they didn't build a mechanism for that to be adjusted to accompany inflation. So some of these soldiers might be taking a little bit of a pay cut as a POW. Also, capture cards have to be completed. A capture card helps document this individual's capture. They are critical to maintain accountability for where that individual is. The International Committee of the Red Cross, the ICRC, maintains a database, a central database of these POWs so that they can be tracked, they can keep in contact with their family members so that they know where they are throughout the armed conflict. And that's important because they can send and receive mail and relief packages as well. This is often a critical lifeline to maintain that semblance of hope, that semblance of humanity while someone is in conflict, in confinement. You can imagine, put yourself in the shoes of a POW, what that means to still be able to get a letter or a care package while you're in confinement. We're going to accelerate because we're close to the end of the hour. For those of you that have to duck at the top of the hour, totally understand, but we'll keep going just to make sure that we hit all of the wickets here. Prisoner of war discipline. What does GC3 say in terms of punishing a POW? Well, POWs are subject to the same laws and policies of forces of the detaining power. So the same rules that apply to soldiers of the detaining force, those apply to POWs. GC3 says that when you're weighing a disciplinary action versus a judicial action, so the difference being a judicial action is something like a traditional criminal proceeding, something that could result in jail time, loss of liberty, etc. The detaining power should favor disciplinary proceedings, these proceedings that are aimed to really reform conduct or address and nip that sort of conduct in the bud, as opposed to judicial proceedings, which have a distinctly different flavor. When it comes to disciplinary sanctions, you see sort of immediately the difference that exists between these and sort of judicial sanctions. You see some overlap there with fines. Certainly you can have a criminal fine in a judicial type case, but revocation of privileges, so maybe your ability to go around, visit the canteen, that sort of privilege. Those who have served, at least in the US military, know very well about revocation of privileges and fines. That sort of thing is used often as a disciplinary sanction for our service members. Fatigue duty, that's sort of duty that's like extra duty, maybe not quite hard labor, but it's maybe less desirable duty. And then confinement not to exceed 30 days. And The Great Escape provides a great example, multiple examples of Steve McQueen's character doing just that as he's thrown in the cooler repeatedly. Now, speaking of Steve McQueen and The Great Escape, what about Escape? That seems like the arch sort of crime that a POW can commit. There's a distinction between an unsuccessful and a successful escape. Now, a successful escape, it's common sense. The POW gets out, they rejoin the force, or they leave the enemy's territory, their control, or they board an allied ship. That is considered a successful escape. If they're later recaptured, they can't be criminally liable for that prior escape. So they can't be punished for the escape itself, the act of escaping. There's a certain assumption that obviously prisoners of war have a high degree of interest in trying to escape. We don't want to set forth a regime where prisoners are just brutally punished for any escape attempt. Now, an unsuccessful escape is divided into two classes. If an escape is unsuccessful, and there's no sort of violence or violence to a guard, stealing, that sort of thing, self-enrichment, then you're going to be limited to disciplinary sanctions. So I picked this great scene from The Great Escape. This American POW repeatedly tries to sneak out by hiding in this case, piles of branch clippings. He's not hurting anyone. He's not trying to kill any Germans in this instance. So they'd be limited to disciplinary sanctions in this case. Now, the difference is that if a POW kills or harms the members of the detaining power in the attempted escape, then you're not going to get combatant immunity for those. So you can be punished for those, and you're not going to be limited to disciplinary sanctions in those instances. Repatriation is one of the last areas we'll hit, and this is an absolutely critical component to prisoners of war. This is perhaps the distinctive feature between a prisoner of war and a normal, just judicial prisoner, because of the baked-in requirement for repatriation. Repatriation is the idea that a prisoner of war or prisoners of war are sent back. They are released to their side. And there are two sort of possibilities, points in time where a POW could be repatriated that GC3 addresses. One is before the end of hostilities, and the second is after. So let's take up before the end of the armed conflict. GC3 mandates that those who are seriously or incurably sick or wounded and those who are permanently disabled must be repatriated before the end of hostilities. The idea is, these folks are better served in the hands of their side. These folks bear no threat to rejoining the force. The entire idea, the concept of a prisoner of war, it's not a punitive status. You're not punishing somebody for fighting in the war. Instead, it is a temporary detainment so that that person doesn't go back and rejoin the ranks and fight against you. So you're allowed to detain them, but once that threat of them rejoining the force goes away, in this case, if they're so wounded, sick, or disabled that that's not a possibility, well, you have no reason to keep them anymore. You have no reason to detain them. They must be repatriated under GC3. What about after the cessation of hostilities? Well, after hostilities, all POWs have to be released and repatriated. That means put back into the hands of their side without delay. There are some minimal exceptions there, folks that are, pending actual judicial proceedings for crimes that they've committed. But this is intended to be a broad brush that gets painted with, because, again, your whole impetus for detaining these prisoners has gone away. The fighting is over. There is no threat that they're going to rejoin and fight against you. Therefore, those prisoners should be released. They must be released. Let's briefly look at NIACs. I mentioned at the start of this presentation that the protections, the scope of protections for prisoners in NIACs, understand there are no POWs in a non-international armed conflict. But the scope of those protections for detainees is much, much narrower. So POW status does not exist in a non-international armed conflict. Only GC Common Article 3, and in some cases, Additional Protocol 2 to the Geneva Convention. Those provide a baseline of protection, really a safety net of protections, if you will. Protection against violence to life and persons. You can't execute or otherwise physically harm, mentally harm a POW. You can't take hostages in NIACs. You can't commit outrages upon personal dignity in a NIAC. And you must provide care for the wounded and sick who are captured during NIACs. And lastly, you can't have punishments by sham courts, these kangaroo entities that give the semblance of a disciplinary or judicial proceeding, but really they're railroading prisoners into all sorts of punishments. Those are prevented. You see there in that list how short that is in comparison to the truncated list of protections that I laid out for prisoners of war in international armed conflicts. AP2 doesn't layer on a lot more protections than the Common Article does. You get provision of food, water, and hygiene that's required, provide safe working conditions for those detainees, respect and the ability to continue their religious practice, the ability to send and receive mail, and evacuation from that frontline combat. And lastly, the safeguards to their physical and mental health. So understand the scope of protections, the regime of protections look very different in a NIAC versus an IAC.